Welcome. I'm Elizabeth Garry, the current Presiding Justice of the Appellate Division, 3rd Department. I'm very happy to be here today with one of my illustrious predecessors, the Honorable Leonard Weiss. Judge Weiss served as the Presiding Justice in the early 90s, the capstone of his long and distinguished judicial career. Before becoming a judge, Judge Weiss served in private practice for 3 decades. His first judicial role was as one of the very first Jewish Albany City Court judges, and he rose quickly through the ranks, from City Court to Supreme Court to becoming an Associate Justice of the Appellate Division and ultimately the Presiding Justice. Justice Weiss was constitutionally required to step down when he reached age 70 in 1993. He remained on the bench for an additional year as a certificated justice and ultimately served 17 years as a judge, 13 of them here at the Appellate Division, 3rd Department. Judge Weiss retired at that time, but it would be fair to say that he has a different view of retirement than many other people. In his retirement, Judge Weiss served as the chair of the Albany County Democratic Committee, and he served on the Electoral College at the time of the election of President William Clinton and Vice President Al Gore. Judge Weiss served as the commissioner of the New York State Public Service Commission and then returned to private practice with the firm of McNamee, Lochner, Titus, and Williams, where he has served as special counsel since 2004. He concentrates on alternative dispute resolution and is an expert mediator and arbitrator, as well as serving as a judicial hearing officer for the New York State Supreme Court. In short, Judge Weiss is something of a legend in New York's legal community, and it is no wonder. Judge Weiss, every year I hear you give the remarks at the annual holiday party for the 3rd Judicial District, and I, like so many of my colleagues, are deeply inspired by your words and your presence. It's an honor to be here and have the chance to chat with you today.
Thank you.
Let's start the questions at the very beginning of your legal career. After serving in the Army during World War II, you decided to pursue a career in law rather than chemical engineering, and that, as I understand it, had been your original plan. What attracted you to the law and to Albany Law School? And did you know what sort of law you would be drawn to?
Well, all my school years, I always engaged in public speaking in citywide contests and in events at the high school calling for public speaking. As a matter of fact, I entered contests at citywide and succeeded in one year in winning. When I left the military, I left as a disabled American veteran entitled to rehabilitation because I was no longer able to go through with the program that I had intended originally. And in rehabilitation, I was offered the opportunity to go to law school, which I very happily accepted and was admitted at their behest to the Albany Law School. And that was the real beginning of my career in law.
What was your first job out of law school?
Well, when I first got out of law school, I was already married to an Albany girl, and my money from the government as a rehabilitation student ceased upon receipt of the diploma. So I was married and I needed some income to support my wife and I. So I took a job as a salesman for a roofing and siding company in Connecticut.
Okay.
Because I was fairly good at speaking, I became very successful as a salesman and began to prosper very much and earn quite a bit of money. And on July 5 of 1948, my mother-in-law called to say that the New York Times published a list and I had passed the bar. Come home. So we did come back to Albany. And my first job, I was now admitted, and I went to the offices of a firm called Koblenz and Taub at 93 State Street in Albany. And Mr. Cobb said to me, I'm going to give you the job, and I'll give you $10 a week. You're not worth it, but you're married to my niece. So I took the job.
And tell us about that early practice.
Well, I involved myself in as many community-wide organizations as possible. I did all kinds of community work, fraternal organizations, religious affiliations, and got to be known by people because I was a stranger and they had to get to know me, which I succeeded in doing. And I loved to do charitable work as well. And I did a lot of that. In fact, I was important in organizing the interracial council in the city of Albany, which was formed by the Father Joseph Seiss of Amsterdam and the rabbi in Temple. And we brought in African American ministers to weld everybody together in a hope that we'd have racial friendship and equality and help each other supportively.
And this time frame is roughly when, Judge?
Oh, this would be in the 1950s, the early 50s. And
so it's just about the civil rights era,
one of the,
as we consider it. You were well ahead of...
Well, I was doing my best to develop a practice and be a significant person in the city.
This is something that aspiring young lawyers who are thinking about being a judge ask often. Politically, did you position yourself to become a judge?
No, I was not enrolled in either party, Democrat or Republican. I had one client for whom I did some work, a wonderful Irish man named Kenneth Canally, and he was important in politics, and he kept urging Mayor Corning, who was chairman of the Democratic Party in Albany, to do something for our counselor. Why don't you give him some kind of a job, make him a candidate? And then one day my wife had passed away, and Mayor Corning knew both my wife and I, and he felt sympathetic to me with sorrow. He said to me, can I do something nice for you? Yes, certainly. He said, can I appoint you a judge of the City Court of Albany? I said, yes, sir, you certainly can, and I'm delighted to. He said, but you have to enroll as a Democrat. I said, yes, sir, I will. And that was the year 1977. And I had to run for re-election in 1977 in November. And I was the candidate of the Democrat, Conservative, Liberal parties. The Republican parties did not nominate an opponent. Rather, they had what's called opportunity to ballot, where Republicans in the primary could write a name in, or anybody's name in. And as strange as it may seem, 109 people wrote my name in, and I became the unopposed candidate in the November 1977 election, and I was unanimously elected. Next year, as I began my campaign in the 7 counties, the Republican Party had leadership in the legislature, and they prevailed upon the governor, Garry, to approve a law which would create an additional judgeship in the 3rd Judicial District. He did, and it turned out I was cross-endorsed and became unopposed as a Supreme Court Justice. And it was then that Mayor Corning said, you've got a career in this business. As a matter of fact, after the second year in 1981, he urged Governor Garry to put me on the Appellate Division after 2 years on the trial bench.
At McNamee Lochner, you've developed a reputation as an expert mediator and arbitrator. As a trial judge, you had a similar reputation for fostering settlements. What's the secret to success in that regard?
Well, whatever degree of success I achieved, I attributed to some factors, some steps that I would take. The first step of all is to really examine what's before me. If it's questions of law, look at them, understand them, and determine whether they were correct or not. If this case was correct under that law. Secondly, I would look at the facts and determine in my mind what kind of relief did these facts call for? What would be the right relief? Third, I would examine the contentions each party was making and determine if they had merit. Why was the plaintiff so firm in this, and why was the defendant resolute in his denial of liability or refusal to honor? Then I'd sit down and I'd make up my mind. Which way would I go? And I'd bring the parties together, attorneys with their clients, and I would explain, I understand what your problems are and what this case is about. I do this separately.
Yes, I was about to ask you that, yes.
Separate and just bring, not the parties then, bring in just the lawyers. And let that lawyer try to explain to me. And then I would say, I'm not so sure. Send your adversary in, step out. And I'd ask the same thing of the adversary.
So you look at the facts, you look at the legal issues, the parties' contentions, and you allow each party a hearing. And privately, separately.
It's a discussion.
Yes.
And then I'd make up my mind, I'd bring them in, and I'd say, look, the key here is compromise. Can we compromise, first of all, on liability in this case, if it's a personal injury case and so on? And try, if we compromise, there is or isn't. If we can't agree on liability, then we can't get a settlement. But isn't it worth it to try to achieve a settlement? Just hold that right there. Now, look, she had pre-existing injuries for which she had serious and extensive medical care. She sustained new injuries that required surgery. A torn rotator cuff that couldn't be done arthroscopically, had to be done surgically. That costs some money. That's pain and suffering. She's entitled.
You point out to each side the pros and cons of their case.
Now look at, why don't you think in terms of $75,000 settle this case for personal injury? Go out and talk to your clients.
Again, it comes back to preparation of the facts, command of the facts.
In the practice of law, whether it's in the first instance as a lawyer facing the client and having to give advice, to the judge having to come to a judicial decision, preparation is mandatory. You cannot do anything if you don't study it and know and be certain what the right answer is.
Thank you. Judge Weiss, as a leader in the legal community, you were well ahead of the curve, if you will, in promoting diversity and inclusion, well before it was a common priority. There are many prominent women litigators in this community who were few and far between when you were a trial judge, who credit you with really reaching out with kindness and helping their careers along. What is it that you attribute that commitment?
A good
Where does
question.
that come from?
Let me start by saying that when I was a student at Albany Law School, there were several hundred students in the three classes of students, freshmen, juniors, and seniors. One woman. All the rest were men. When I got admitted to the bar of the city of Albany, the county of Albany, 1948, two women in all of the lawyers practicing. I knew that wasn't right. When I got on this appellate division, there was one woman. She was from Buffalo, Judge Ann Michael.
Yes.
And she was the only woman on it while I was on the court until Anthony Cardona's term, when Karen Peters from Ulster County became an associate judge. She had
Yes.
been a judge in Ulster County. And then she became the presiding justice.
Yes.
And very fortunately, she was succeeded by another female judge.
What advice would you give, Judge Weiss, to attorneys today who are just starting their careers?
Be public. Join organizations. Volunteer to do work in your community. Be active in the organizations to which you already belong, religious and otherwise. Volunteer is a big thing. Do work via volunteer for legal aid too, brings a lot of work, service. Make yourself known. But the important thing is, never, never open your mouth to say something that you don't know is right. Unless you're saying this is an issue which is undecided and unresolved, and it's out there for all of us to resolve. But don't you give advice if you don't know what you're talking about and you don't know that you're right.
Judge Weiss, I'm often asked, and I'd like your thoughts on this, how important is oral argument?
I think oral argument is very important. You know, in preparation, I always read every brief and knew what to expect was going to happen. And we're prepared if a new direction or concept comes up on oral argument, then and only then to ask the question. If I disagreed with something that was in one of the briefs, I would say, ask a question, do you or don't you find the following to be significant in this case? And see what the answer would be. But when a brand new sentence or paragraph came out in oral argument, that prompted sometimes questions. But oral arguments are always meaningful. Naturally, not every speaker is as fluent and as others, but oral argument itself means something.
What advice would you give to someone who might be serving as a senior partner in a law firm?
Well, congratulations on achieving seniority. Never forget what it was like when you came in as a newcomer and the work that you did, how hard and how diligent you were, and how successful you were in ascending in importance in the firm to the point where you've become a partner.
Judge Weiss, do you have advice that you would offer to your colleagues on the bench?
Well, yes. Never forget the reason you're there. You're supposed to be correct in what you do. Make sure you prepare yourself. with whatever you're about to write or to say. Be energetic, be diligent, be dedicated to being right. Never lose respect. Remember, the people that are coming before you are seeking relief. And those who come before you are denying that they did anything wrong for which they should be held responsible. You're going to decide that. And don't ever, ever take things for granted. Be patient, be understanding, be tolerant, be attentive, and be dedicated to trying what you sincerely believe is the right end result. And I want to say this. I want to bring this out.
Fine. Good. Go for it.
The Constitution of the United States established three branches: the executive, the legislative, and the judicial. And it says they're co-equal. Well, you know what, Judge? They're not co-equal. It's the judiciary that's supreme. Because whatever the executive does, whatever the legislative does, can be challenged by the public. They're there to preserve, protect, and defend the rights of all the citizens. And it's when they're not doing what citizens think is right, they are challenged. And where do they go? To their lawyer, and then to the judiciary. And it's the judiciary which is the last word in government. And Lord only knows the life in which we live this very day is going to be totally dependent upon the judiciary. Ultimately, the federal district courts, the federal appeals court, and the Supreme Court of the United States. Does the president have a right to, on his own, unilaterally foreclose the acts of the House of Representatives by telling each person who's been subpoenaed, you are not to respond, by telling each person who is questioned, you are not to answer, by telling the Congress, the House of Representatives, you don't have the right to do that, by telling the world that the Mueller report is not valid, is illegal, telling Mueller, you can't testify. The people who worked on it, you can't testify. This is without going to whether or not there was illegal activity on his part in his campaign and in his dealings with Russia or not. But the point is, it's the judiciary, the legal system and the judiciary, which is the only place that all of the citizens of this country, whether they're immigrants coming into the country or all of us who are here whose ancestors were immigrants, the only Americans are the Indians. Everybody else is a descendant of an immigrant from another country. And we're all equal, this generation and our forebears, equal and entitled to the protection, the preservation, and the defense of liberty. And it's the judiciary that will give it.
Upholding the rule of law. That's our role.
That's it.
You've spoken for decades about the gravitas of a judicial position, and in particular, the significance of the Appellate Division. Can you elaborate on that?
Yes, but first I have to say that I was so fortunate on the Appellate Division to have as my confidential law assistant, Michael Lynch, who was a very young lawyer who had a small position upon graduation or admission with the County of Albany, and he became my confidential law assistant. And I was overwhelmed. He was so brilliant. Everything I asked about.
We continue to gain from his brilliance
I'll
through
say
the
this
present.
to you. We sat opposite each other in the library on Eagle Street, and we never had a disagreement on anything other than our versions of cases. But we each studied every case. We got all the briefs and the records, and we were prepared.
Right.
And
again, it's that prepared. That's the key.
And we formulated cases together, and Judge Lynch was virtually my son. We were that close, and I loved him.
The legal community was quite close. I think that you had the privilege of working with a great number of good colleagues, and I know you've told some stories that I think our audience would like to hear about. Some of those lunch times, and the down the hall, and I've had that benefit, but I don't think everyone has.
Well, our chambers were on Eagle Street in the Albany County Courthouse. On the second floor, and across the hall was Supreme Court Justice Edward S. Conway, who was the district supervising judge for the district. And his confidential law assistant was William McCarthy, who later became an associate judge. And every day at lunchtime, we would meet, the four of us, Judge Conway, William McCarthy, Michael Lynch, and I, and whatever other judges happened to be in the building, whether they were Albany judges or visiting judges assigned for trial. And we would march up in a parade up Eagle Street there, up the street to a small little restaurant there. The name just slips me now. But we had lunch there every day around the table, and it was just a great experience. Other diners, other people at the bars we walked in would be very glad to meet you. How nice to see you, Judge. How are you? All of us, everybody knew people. And that became a legend. When other judges came, they all wanted to come. We go to lunch together. I can't tell you the quality of the judges that I have been so privileged to serve with. It's been so superb, so exemplary. I can't remember any occasion in which I would say anything negative. Maybe negative about one of the decisions, but not negative about a judge. And to me, this court is so distinguished, so exemplary, so outstanding, that in all the years that I was on this court, wherever I went, whether it was in an Albany County or a county bar association, whether it was in a meeting of the New York State Bar Association, whether it was in a meeting of the people of the city of Albany, whether it was a meeting of judges, of the justices of the Appellate Division, or justices of the state of New York, Court of Supreme Court judges, whether it was to other Appellate Division judges, or whether it was in the presence of the Court of Appeals, the crown jewel of the judicial system in the state of New York is the Appellate Division, 3rd Department.
As I introduced you, I laughed because you hit a retirement age, which clearly was not a retirement for you, Judge. But as you approached your departure from the bench, was there anything particularly meaningful at that time?
A dear friend, Owen McGivern, the presiding justice of the 1st Department, I attended a retirement party when he reached 70. And he stood up and he said, 70 isn't the end of life. He said, it's not the end of it. He said, Gladstone was the Prime Minister of Great Britain at age 85. And Konrad Adenauer was 86 when Germany made him the Grand Chancellor. And Michelangelo was painting the Sistine Chapel when he was 90 years of age. And he said, Cicero wrote, I never met a man so old he forgot where he hid his money. Robert Browning, the great poet, wrote, age is not the end of life. Walk with me. The best is yet to come. And that's what I remember. That's all I have to say.
Thank you for those kind words. Judge Weiss, what a pleasure it has been to visit with you this afternoon.
Thank you for honoring me.